I'm never going back to my school. Good morning, everyone. We're about to go on the record. We're continuing the matter, complicated matter of Rosemary Blair versus Joseph O'Donnell and Carla Bowers. It's had quite a procedural slog through the system, been adjourned several times, continued several times. I blocked out the entire day today for the matter. We have two new attorneys that will be appearing here, Robert Soltis for Rosemary Blair, and Jennifer Wu will be appearing for Mark Verpalat, one of the third-party defendants. Anyway, good morning, everyone. Let me get started here. For my Rutgers friend, I finished in second place at the end of the Learned League season. I think I'm in like a remedial division, but it's the highest I ever was. All right, let's go on the official record. This matter is entitled Rosemary Blair versus Joseph O'Donnell and Carla Bowers. The file number is 221862. There are three third-party defendants, Mark Verpalat, Patrick Blair, and Karen Stiver. Attorney Daniel Hatch is here on behalf of Joseph O'Donnell and Carla Bowers. Mr. Soltis, why don't you go ahead and put your appearance on the record?
Thank you, Your Honor. Robert A. Soltis on behalf of Rosemary Blair. Ms. Blair is right to my left.
Good morning, Ms. Blair.
Good morning.
Mr. Hatch, why don't you go ahead and place your appearance on there as well?
Good morning, Your Honor. Dan Hatch on behalf of defendant counter plaintiffs Joe O'Donnell and Carla Bowers,
Who are both present also. We have a new participant here. Attorney Wu, would you come up and place your appearance on the record as well? Come up to the podium if you would.
Sorry.
Just come to the podium there so you'll be on camera.
Oh, lovely. Jennifer Wu of the law firm Lewis, Reed & Allen on behalf of third-party defendant Mark Verpalat.
Thank you very much.
Thank you
for being here. Theoretically, this matter was set for a hearing regarding damages in this matter. As I indicated, it's got quite a procedural history. We were here on May 26th and made a pretty extensive record. And Mr. Hatch presented an order to reflect my finding where I denied plaintiff's motion to set aside the default. Mr. Hauser filed an objection to that, so that order has not been signed. It just simply states, for the reasons stated on the record, the court being fully otherwise advised in the premises, it is hereby ordered that the motion to set aside the default against Rosemary Blair is denied, which was accurate. But there's a question about whether it's denied with prejudice or without. I'm not sure what difference it makes, but anyway, that order has not been entered, but I did deny the motion to set aside the default. The default entered. There was, I believe, a non-timely motion to set aside the default, which didn't comply with the court rule. It was just a one-page thing that said I moved to set aside the default, so I denied the motion to set aside the default because it didn't comply with the court rule. Shortly after that, Ms. Blair indicated she didn't want Mr. Hauser to represent her anymore, and he was released from his obligations. So we didn't do what we had hoped to do on May 26th. I again blocked out that entire day, or maybe just the afternoon, but I blocked out a block of time. So we searched for another day, and today is a jury trial day, and the two cases that were set for jury trial, fortunately, both resolved. So I blocked out all day. So Miss Blair, at that point, asked for an adjournment because she didn't have counsel. Mr. Hatch objected to that, but I felt in good conscience she needed to have representation. It was clear she didn't completely understand everything that was happening here, not because she's ignorant, but because she's not an attorney. And so I did continue the matter. She was scheduled for a deposition on June 12th. And was that the date, Mr. Hatch?
I believe it was June 16th, Your Honor, which was a Friday.
All right, June 16th.
Correct, Your Honor.
And there were some last minute scrambles. She requested to not appear. I denied that request. There was another attorney in there somewhere from Crown Point or somewhere in Indiana, said she has to be there. She didn't appear. So a separate record was made. She wasn't present. Mr. Hatch requested contempt, jail, attorney fees, and a number of other things. And that matter is somewhat left open as well. So we've got the issue regarding the entry of the original order. We've got the issue regarding the contempt of Rosemary Blair. And theoretically, this matter is set for a hearing regarding damages. I raised the issue multiple times regarding the plaintiff's request for damages in excess of $25,000. All of the third-party cases, the claim, counterclaim, or third-party claim is in excess of $25,000. By statute and court rule, the district court has jurisdiction in matters up to $25,000, including landlord-tenant matters. And the court rule, it's in 4.2 something.
4.201, Your Honor.
4.201. Doesn't really give the court discretion. It says if either party moves to remove the case, the court shall remove it to the circuit court, not may, shall. This comes up several times a year. So that issue had never been joined. It was discussed. Mr. Hauser never made such a motion, and neither did Mr. Hatch, and the court didn't make one on their own. Frankly, I didn't want to dump this matter all on the circuit court. It's complicated, it's fact specific, it's got a lot of previous court proceedings, and to remove the matter, I think would put great amount of delay and expense. So in hindsight, maybe I should have removed it right from the get-go and let the circuit court start with it, but we did not. So Mr. Soltis, who appears before this court quite often in landlord-tenant matters, has filed an appearance on behalf of Ms. Blair, and he's challenging the jurisdiction of the court to determine the damage question, and that it's over $25,000. Normally, the district court does not have equitable jurisdiction. But in some landlord-tenant cases, there is some equitable jurisdiction. And in this case, by default, I have ordered specific performance that she comply with the terms of the original lease, option to buy, or land contract, or whatever we're going to call it. So they've asked for specific performance. We want to buy this house at the agreed upon price, and that's been ordered. We haven't nailed the terms down, but that's in the pleadings. It was subject to the default. It was not set aside. So where does that leave us? Let's start first with the entry of the order. Mr. Hatch, you submitted the order as I directed, and it states that the motion to set aside the default was denied for the reasons stated on the record, which I've restated here. Do you wish to speak to that any further?
I do, Your Honor. Thank you, Your Honor. Dan Hatch on behalf of Joe O'Donnell, Carla Bowers, and may it please the court. You're right. The May 26th order, I drafted it. I submitted it under the 7-day rule. A couple things. Number one, Mr. Hauser was terminated as Ms. Blair's counsel on May 26th in front of this court. He withdrew his counsel. He no longer represents Ms. Blair. The court denied the motion to set aside the defaults because it found, as we briefed, that there was no meritorious defense and no good cause to set aside the defaults. So I offered to submit an order. I submitted an order under the 7-day rule. It stated that the motion was denied for the reasons stated on the record. And I put with prejudice, as I do on most motions, because you can't just bring the same motion over, and there's a way that you can seek relief from the court. It's called the motion for reconsideration. You can't just file another motion because you hire a new attorney and now you want to try to bring it again. So that's why I put in the order it's denied with prejudice, which it was. Ms. Blair, Mr. Soltis could file a motion for reconsideration, which they have not done so far. So number one, the order is accurate. And number two, it's precarious that Mr. Hauser would be filing an objection when he doesn't represent Ms. Blair. He was relieved of his duties to represent Ms. Blair. He still is counsel of record for Karen Stiver and Patrick Blair. He has no standing to object to an order that has nothing to do with his clients, who are Karen Stiver and Mark Verplat. So for the reasons that the order is accurate and the fact that Mr. Hauser doesn't have any standing, we would ask that the court enter the order as it was submitted. Thank you.
Mr. Soltis, do you have any comment regarding that?
Yes, Your Honor. A couple things. If the court is ordering that order that was presented be entered, the time for reconsideration hasn't even begun, never mind passed. So that's still open. I've gone and looked at the tapes that we were made of the hearings in the past. I don't believe the court said with prejudice or without prejudice. So what my request is, Judge, just strike out that last language and let the order accurately state what you did. You denied the motion.
And I didn't state it, so that is what I'm going to do. I'm just going to take that out. Counsel's right. You can't just refile the same motion over and over again, but there is a way to do it. So I've stricken the last two words with prejudice, and I've signed the order. Somehow it's got a 220. So the date of the order is today, 6/28/23, denying the motion to set aside the default. It has the same effect. That order remains, including the order for specific performance. All right, the next issue is regarding the contempt of the defendant, Rosemary Blair. Mr. Hatch was quite vocal in his objections. He was here. I don't I don't think they ended up bringing all their, everything they needed, but he was here prepared to do the deposition. She was told on the record she was to be here. There was an order denying her request to not come, and she did not come. So we're here for today's hearing. Mr. Hatch has not had an opportunity to depose Miss Blair. She wanted to tell her side of the story. And she said, when do I get my turn? And I said, well, I'll get the turn at the deposition and at a later hearing. So this record was made without counsel being here, without the defendant being here, and I didn't make any finding. So at risk of having you say everything all over again, what's your position regarding the contempt of the plaintiff, Rosemary Blair?
Thank you, Your Honor. I won't rehash everything that we talked about on the 16th already, but the motion for direct contempt was entered by the court on June 16th. So as I stated, we've got various sanctions and relief that were requested in the motion. Some of those are moot at this point, but at this time, we are asking for two forms of relief for the direct contempt. So under MCL 600.1721, following the finding of civil contempt, the court may order any or all of the following sanctions: a fine of not more than $7,500, a coercive conditional jail sentence to compel the party in contempt to comply with the order. I understand the court has denied that. And if applicable, damages for loss or injury caused by the contempt conduct. So it's up to the court to decide whether they want to impose a fine. We would be asking under MCL 600.1721 for damages for loss or injury caused by the contempt conduct. Those damages are, as we state in our motion, $6,500 that we incurred, and that's not the total expense, but I think that is a reasonable expense for Ms. Blair failing to show up for her deposition twice. She failed to show up for her deposition on May 16th, and she failed to show up for her deposition in direct contempt of this court's order on June 16th. So I prepared for Ms. Blair's deposition twice. I drove to Mr. Hauser's office. Here is the deposition exhibit book with all the exhibits that I was going to go through with Ms. Blair. It was going to last all day, 7 hours. I spent a significant amount of time preparing for a deposition of a critical witness in this case. So it's not like something I was just going to do in 2 or 3 hours. I spent a lot of time preparing twice for a deposition. So at my rate of $395 an hour, which is reasonable under the per group factors and under the State Bar of Michigan State Law and Economic Digest, it's 16 hours, which would be very reasonable for my travel time from Grand Rapids to Kalamazoo to Mr. Hauser's office, which Ms. Blair didn't show up to, and from Grand Rapids to the courts, which Ms. Blair didn't show up to, in addition to the preparation for the deposition twice. So those are the money sanctions we're asking for. Also, as a sanction for her failure to comply with discovery, MCR 2.313, which is failure to permit discovery sanctions, under section MCR 2.313 B2 subsection B. If a party or an officer, director, or managing agent of a party, or a person designated under MCR 2.306 to testify on behalf of a party fails to obey an order to provide or permit discovery, including an order entered by the court under subrule A, the court in which the action is pending may order such sanctions that are just, including but not limited to the following. So subsection 2 has been met. Ms. Blair failed to appear for her deposition and permit discovery twice. Subsection B states, an order refusing to allow the disobedient party to support or oppose designated claims or defenses, or prohibiting the party from introducing designated matters into evidence. So in addition to the monetary sanctions, we are asking for the sanction to prohibit Ms. Blair from supporting or opposing our claims today for damages. And that's probably the next issue we're going to get into, which is what are the claims and what damages are going to be presenting. But that is the sanction we're asking. There's no trial by ambush. I have the opportunity to depose Ms. Blair before the trial. If she wanted to tell her story, she should have come to the deposition twice. It's not fair for her to duck out in a deposition and then try to hoodwink us at trial by going up and testifying when I haven't had an opportunity to depose her. If that was the rule, no party would ever show up for a deposition. They would just try by ambush every single time. So there's reasons for depositions. Miss Blair chose not to show up for a deposition, and there's a court rule specifically stating that if the disobedient party fails to permit discovery, i.e. a deposition, that the court can prevent her from supporting or opposing the designated claims. That's directly on point and what we're asking here for today. So $6,500 of our expenses incurred for the direct contempt, and that also prevent Miss Blair from testifying, opposing our claims, or admitting any evidence in this hearing or any subsequent hearings in this matter. Thank you, Your Honor.
Mr. Soltis?
Yes, Your Honor. Ms. Blair informed the court that she couldn't be here because of a doctor's appointment. And that information, according to the Register of Actions, was transmitted to Mr. Hatch before the death. So, and then my understanding is he came down here and he was down here anyway. He said to the court, yeah, I'm down here anyway, so, let me take care of that. Well, Your Honor, first of all, if he drove to Hauser's office, I don't know that. I've not seen any bill of cost here or anything like that. So I don't have that information, so I can't respond to how much time and whether or not that's reasonable. If I had it, I could, but I don't. Second of all, Your Honor, when he says he has to prep twice, I don't think I would do that, and I don't think that's reasonable.
I can identify. I've had this file out 15 times and I get all ready to go. And one day we got tornadoed. It was nobody's fault. And I had everything, spent 2 days going over everything, was ready to go. And the tornado never came, but they shut the courthouse down. So we had to move it. Then I had to do it all over again. Then we were here on the 20th, in the date in May, and I prepared everything. And Mr. Hauser was removed, and so we didn't do anything. So I had to prepare all over again. So I can identify with having to get ready over and over again. My memory isn't what it was when I was 25. And so I have to reacquaint myself every time I have to dive back into this big, thick file.
Well, I understand that completely, Your Honor. However, Mr. Hatch claims that he's got a big old binder here, which means he prepared. And for him to go through that all over again, I think would either take a very little time, if he's even going to go there. I normally write down my questions before a deposition. And, oh, by the way, if I have to take the deposition later on, I look at my questions, they're already there. So it's not a chance where he has to go through the whole amount of evidence that you had to go through, but just whatever he wanted to ask of Ms. Blair. And Your Honor, there was no trial, and right now there is no trial. So I think the sanctions, yeah, there should be some money sanctions against Ms. Blair. $6,500, I can't tell you whether that's good or bad or indifferent, but I do think it's maybe a little, maybe high. I think Ms. Blair should be able to question the damages and present evidence that, the evidence is not correct. One of the issues in this case that I know the court has mentioned before is how much money was given to Ms. Blair for representing the down payment, if you would, on the lease option. It's not a land contract, the lease option. And, that is probably going to end up being determined by the circuit court. I've talked to Mr. Hatch, And I think we both are in agreement. He can disagree with me if he wants, that because of the fact that the court doesn't have the jurisdiction over 25,000, that if the damages here go over 25,000, that's got to go up to circuit too. And I know it's not the ideal resolution, because I know the court doesn't want to send this up to the circuit court, because it'll take a bit. But on the other hand, if it goes over 25,000 and this lawyer is required to appeal, that's going to take even longer. And, I don't think I think the only solution is to send this to circuit court. As for the deposition.
Well, why don't you go ahead? You sort of segued into your motion regarding jurisdiction. And why don't you address that further?
Your Honor, if I could just, before we segue into the jurisdictional issue, if I could just make a couple comments about the cost.
Yes. Stop. I'm ordering $6,500 in costs.
Okay.
She explicitly did not have my permission to not appear. I told her to be here. I did an order that said she didn't have the right to be here. I think it was a pretext that she was trying not to come. So you prevail. I'm not ordering 7 days jail or a $7,500 fine or the other things you asked for. However, I'm ordering your costs. So you may do an order that Rosemary Blair, as a sanction for contempt, shall pay $6,500.
And Your Honor, we did put in the motion as well, because I've ran into this issue before, that, when is that due and payable? So we have asked that she tender payment to undersigned counsel to my firm IOTA account within 14 days of the court's order, just so that there's a cabin date on when it is due.
Your Honor, because of the amount, I would ask that it be 30 days.
That's fine.
And just very, very quickly, Your Honor, I don't want to get into, I understand the $6,500, but to Mr. Solis's comment about prepping twice for a deposition. When I showed up on May 26th.
You already won.
I know,
so I may just make you feel better. But
I take offense to the fact that if someone thinks that I'm churning the file, I don't work like that. When I showed up to Mr. Hauser for the first deposition, we had a very good conversation about a lot of things that he didn't know about the case. And he turns over to me a massive file that he failed to produce in response to our discovery request. So the additional amount of damages, it was not just me going through my questions again. It was, I added a significant amount of exhibits because there was a lot of documents that had not been produced before that day. I just wanted to put that on the record.
all right. Well, you can do the order. The defendant has been found in direct contempt on the 26th of May. As a sanction, I'm ordering she pay $6,500 in costs for her failure to appear. I'm not ordering any jail sanction. We have yet to address the issue of whether she can present any evidence, but as indicated, that may not end up being here. You can do the order. 30 days from today would be July 28th. All right. Again, I stated my position on this. Maybe in hindsight, I should have just sent it upstairs right from the start, but I was hopeful I could get this case over the finish line. Mr. Soltis has come into the case on very late notice, and he went right to the pink elephant in the room regarding the jurisdiction of this court to hear the damage claim. Mr. Soltis?
Yes, Your Honor. As I presented in a hearing brief that unfortunately I was only able to file yesterday, is that whenever the court rule and the statute and the case law all says that the court cannot has no jurisdiction to enter orders over and above the $25,000 limit. And every one of the claims from the counter complaint that are for damages are asking for $25,000 or more in excess. And as the court, as my brief pointed out, Your Honor, you look at right at the beginning. You don't go way down the line and wait and see if they can prove it. You have to look at the beginning. And if the claims are on their face in excess of 25,000, they need to go up. And Your Honor, I also put in the fact that when there's two exceptions to the rule that attorney's fees are generally not included as damages, but that's beyond the point. But I'll just say it anyway. The two exceptions, as I noticed in Michigan, is if there is a statutory basis for the attorney fees that will allow for attorney's fees. And Mr. Hatch has pled MCL to 600.2191A, which certainly provides for attorney's fees if it becomes that way. And based upon what we hear today, that's going to be well over 25,000. So, Your Honor, I think the only issue that I think the court can address today jurisdictionally is the
Specific performance.
right. And the court has already done that. So when we get to specific performance, well, I think it's premature as to what happens because, there's the contract has to be followed. There has to be certain requirements, notice 90 days and all that sort of thing in a closing. We don't know if that'll happen yet. And if it doesn't, then the specific performance, I think, just dies because, if Mr. O'Donnell and Ms. Bowers don't specifically perform as the court has ordered, well, then they don't get the property.
Well, there's another wrinkle in this. In August of 2021, when the inspection took place and that Mr. O'Donnell and Ms. Bowers were removed from the house, that the closing date, I think, was November 30th, maybe November 1st. Anyway, it was in November. Interest rates were probably 3.8%. And the testimony I recall from earlier representations were that they had been working with a bank to secure the financing to close by the date in the lease option to purchase. There was also testimony that they'd been making monthly payments. That was disputed, just like the large payment that they contend, but they also contend they were giving her, I think, $2,000 a month. Anyway, to close the deal in August of 2021 would cost them X amount of financing costs. To close the deal in August of 2023 is 2023, it's going to be more expensive for them to borrow the same amount of money. So that is part of the damage question rather than the specific performance. Purchase price for the house was $450,000. There's also a dispute as to how much was paid in advance.
Right.
So let's assume that their representation is correct, that they've paid her approximately $120,000. Now, there have been escrow payments being made each month here, which the court is also holding. So let's assume there's $130,000 that have been paid by the defendants. That leaves $320,000 to specifically perform the contract. The problem is that earlier money is in dispute. So your statement's got some validity. How do they specifically perform the contract? I guess they could come in with $450,000 and say, I want the title of this house. and then fight about the rest of it. But it isn't as simple as it was at the time they were removed from the house. So you are specifically requesting this court to remove the matter to the circuit court.
Correct. And Your Honor, let me kind of elaborate on my thoughts on this. First of all, if there was a provision in the agreement that says they're going to buy the house at 450 at 6% and whatever percent, and the interest rates are above that now, or when they actually do try and buy the house, I guess, they actually exercise that option, then we will know that as a measure of damages. But the contract doesn't provide for that. It provides for,
Well, you give me the money, we don't care how you get it.
right, and there's a chance that Mr. O'Donnell and Ms. Bowers can pay cash, and there goes the whole interest aspect of it. They pay cash, we don't know where it came from, and we don't care. But if they pay cash, then they're not financing, and the interest rates are, I think, irrelevant. Plus, between now and then, I think the interest rates may change. In fact, I'm confident they'll change. Come on, the way the Fed's been doing it, they've been changing the rates about every other month.
All right, thank you. Ms. Wu, while you're here, would you come up? Are you going to request that I remove the case as to Mr. Verpalat as well?
That's correct. There's one claim made against him by the defendants, third-party plaintiffs for tortious interference, and that is in excess of 25 that we would ask that be removed. I did have a conversation with Attorney Hatch prior to today's hearing. There had been a discussion of a bifurcation of the claims. I'm not sure exactly what is remaining in the landlord-tenant action, but I would agree to have that removed, or at least for my client's claims to be removed to circuit court because of jurisdictional amount.
All right, that pink elephant has been in the room since that third-party claim was filed. Again, I didn't do it on my own motion, neither party removed it. I raised it again at our last hearing, or just before Mr. Hauser was, no, Mr. Hauser is still in it for Patrick Blair and Karen Stiver. All right, so again, I have a specific request to remove that, and I don't have any discretion in the matter. So, all right, we'll hear from Mr. Hatch and see what he's got to say. Thank you.
Thank you, Your Honor.
Thank you, Your Honor. I think there's a really easy solution to this, and I agree with about 70% of about what opposing counsel said here. So, which is good.
Right.
So it's a good start.
It's better than zero,
It is.
I guess.
It is. We would stipulate to bifurcate this case as to certain claims that exceed the jurisdictional threshold of the district court. The claims in this case are count 1, breach of contract, count 2, specific performance, count 3, violation of the anti-lockout statute, count 4, tortious interference, count 5, summary proceeding, count 6, quiet title, count 7, civil conspiracy, count 8, common law conversion, count 9, statutory conversion, count 10, trespass, and count 11, claim and delivery. So I believe the court was.
Where was specific performance in there under breach of contract?
That is count 2. It's right after breach of contract.
All right.
MCR 4.002, which I think the court was referencing, states, if a defendant asserts a counterclaim or cross-claim seeking relief on an amount or nature beyond the jurisdiction or power of the district court in which the action is pending, the court shall either order the action transferred to the circuit court to which the appeal action would ordinarily lie, or inform the defendant the transfer will not be ordered without motion and notice to the other parties. So I think that's where you start out. But you have to specifically look to MCR 4.201. And that specifically has to do with removal of certain claims from the district court. MCR 2.401 subsection G2, claims and counterclaims. Removal.
Give me a second. All right, what section are we referring to?
Subsection G2, titled removal. G2, subsection A and B.
Okay.
Subsection A states under removal, a summary proceeding action need not be removed from the court in which it is filed because an equitable defense or counterclaim is interposed. Subsection B, if a money claim or counterclaim exceeding the court's jurisdiction is introduced, the court, on motion of either party or on its own initiative, shall order in accordance with the procedures in MCR 4.002, which is the original one we just went over, removal of that portion of the action to the circuit court if the money claim or counterclaim is sufficiently shown to exceed the court's jurisdictional limit. So Ms. Blair has asked that the court just kick it all up to the circuit court. It's not how it works. So we would agree to bifurcate this case, the claims in this case with respect to count 1 breach of contracts because the damages do exceed $25,000. Count 3 violation of the anti-lockout statute, over $25,000. Count 4 tortious interference. Count 7 civil conspiracy. Count 8 conversion. Count 9 statutory conversion. Count 10 trespass. Count 11 claim and delivery. We want to do that for a couple reasons. Number one, we want to make sure that this case is appeal proof. And also we want to make sure that if we're in district court for our money damages claim, we're capped at $25,000. We don't want that.
Well, or if I granted more, certainly it'd be subject to appeal, and
Yeah.
nobody wants to do this twice.
Right. So those are the money damages claims. So we will stipulate under MCR 4.201, and I've had conversations with both opposing counsel before today, that we'll stipulate to count 1, count 3, count 4, and count 7 through 11. The court does not have to and should not kick up the claim for specific performance, summary proceeding, and quiet title. Those under MCR 600.8302, equitable jurisdiction of the district court. This court has jurisdiction under those claims. Specific performance is an equitable claim. It's attached to a breach of contract claim, but we're asking for equitable relief in the form that hopefully we'll be presenting here today. Summary proceedings, again, the district court has exclusive jurisdiction over, and also quiet title. So MCL 600.8302 subsection 3 states, in an action under Chapter 57, which is the Summary Proceeding Act, the district court may hear and determine an equitable claim relating to or arising under Chapter 31, 33, or 38, or involving a right, interest, obligation, or title in the lands. That's what our specific performance claim relates to. That's what our summary proceeding claim relates to. And that's what our quiet title claim relates to. So the solution, to this puzzle is simple. We will stipulate to bifurcate the case with respect to the claims that I identified, and the court should hear, because you've already entered a default, not a default judgment with respect to count 2, 5, and 6. So we're here today, and it would be a logistical nightmare to try to transfer those claims. This court's heard this case for 6 months. We're at the finish line. So we asked to proceed with count 2, count 5, and count 6. And the time is today to proceed with those claims. So you don't need to kick the entire case up to the circuit court. The money damages can go up there. We'll have a hearing on money damages for those claims. And then the summary proceeding, specific performance, and quiet title will be handled by this court. Thank you, Your Honor.
All right. Before you respond to that. how do we accomplish specific performance? As Mr. Soltis says, if they come in with $450,000, we don't care where it came from. So I would order that, and the problem is for your client, let's just assume, as she argues, she's received zero. That's not accurate because there's some money in escrow, probably $6,000 to $8,000. They've paid 3 or 4 months worth of payment in escrow. But absent that, they've got to come up with a whole $450,000. Then I order that they quiet title and the summary disposition for removal is denied. And they pay $450,000, they get the house and the deed. Then your next 2 years fighting over damages in circuit court. Is your client prepared to do that?
The way that I see that's the most efficient process, Your Honor, is that we have a hearing. So the court has entered a default, not a default judgment on specific performance. Default establishes liability. A default judgment establishes damages or the remedy. So while the court has already entered default for specific performance, we need to offer proofs here today to address exactly what the court said. Ms. Blair claims she received $30,000. We will present evidence today that's incorrect. That goes into the amount that they paid under the land contract, which then goes into how do we determine the equitable remedy of specific performance. So we do need to put proofs on here today to enter a default judgment. Again, I want to make this appeal proof. Just the default doesn't do anything for us today. The court has to hear our proofs as far as formulating the equitable relief under specific performance. So, and this will be part of our trial here today, is that equitable relief is beautiful for specific performance. The court has discretion to create a lot of different remedies. So we will be asking the court to compel compliance with the closing of the transaction, the original 90 days, as set forth in the land contract, less the payments that have already been made to Ms. Blair, which we'll enter proofs with here today, and that she, it's in our complaint, but that she tender the sale and the instruments for delivery of the property over to my clients. And then that amount will be offset through set off and recoupment, which the court has the equitable remedy to do, from the amount of damages that are determined in the circuit court.
And see, I'm not going to do that. At least we won't be able to accomplish that within 90 days.
Well,
I'm willing to hear testimony regarding your contention that certain amounts were paid. Your set off in attorney fees is probably going to be in excess of $100,000, but I'm not going to fry that fish here. That's going to be a circuit court matter. But you do have a leg to stand on regarding the first portion. As a practical matter, I could just remove the whole thing to circuit court. I didn't want to do that. If the matter is removed to circuit court, you might assume this is going to take 2 years. All the transcripts of all the proceedings are going to have to be prepared. Judge Stutzman's going to have to familiarize himself with all these complicated claims and counterclaims and previous orders entered by the court. They've got to schedule it for hearing. There may be further depositions. It's going to take a long time and cost a lot of money. If I can accomplish the specific performance and give the buyers a certain dollar amount and date and compel Ms. Blair to tender the deed, that portion is done. They would own the house. Then you can spend 2 years fighting about the money. But I'm not going to go down the rabbit hole of all of the other stuff to offset the amount. If you want it removed to circuit court by stipulation, that will be a money question. So, Mr. Soltis, your response?
Well, my response.
Well, first of all, he agrees to now regarding the third party claims, my inclination is to simply remove all 3 of those right off the bat, rather than get caught up in this. The damage is clearly in excess of $25,000. But regarding Rosemary Blair's specific performance claims, he proposes to present evidence as to how much was actually tendered, so I can give a figure for the defendants to comply with the purchase price. What's your response?
My response, Your Honor, is that specific performance means exactly that. Specific performance with the lease agreement. And if you look at the lease agreement, there are provisions that even after 90 days, we won't know exactly what the amount is, because it says, in the event there is an unforeseen delay for any reason, the purchasers shall pay $1,000 monthly until financing is secured. Will they pay it? And, in my opinion, this is still a question of whether or not they will actually exercise that option. And if they don't exercise that option, they don't get the house.
Correct. But I'm going to tell them you've got to exercise the option by a certain date for this amount of money.
And they need to also follow the other requirements of this contract. Do they not?
Yes.
Okay.
Which are what?
I just told you. It's $1,000 a monthly if it isn't. If they cause damage.
Well,
there's
right
other-
now, they're paying $2,000 a month into escrow by court order. And to my knowledge, they haven't missed any payment. So, all right. This is going to take us all day, but that's why we blocked out the day. I'm going to allow you to present evidence regarding the amount that you contend your clients have paid, either in direct lump sum or in monthly payments. And Ms. Blair is precluded from testifying in opposition to that because she didn't show up for a deposition twice. So I'm going to take your evidence essentially unchallenged. He can certainly cross-examine and argue about it, but you're right. If you could fail to appear for a deposition, then show up at the trial and give your testimony. What's the point of compelling a deposition? You just duck it by not appearing. So you can't have it both ways. So we're going to take a recess. I will, Ms. Wu, I would ask you to prepare an order removing Mark Verpalat's case to the circuit court. I will do an order. Mr. Hauser is still actually counsel of record for Patrick Blair and Karen Stiver, but I will do an order removing those matters also to circuit court. So the third party claims all have to do with money damages, and they'll be in circuit court. I will accept defendant's offer to remove all of the money claims to circuit court. And Mr. Hatch, I'd ask you to do an order to that effect.
Certainly are.
And we're going to address the three non-money aspects of the complaint: summary proceedings, specific performance, and breach. Oh, what's the third one? Quiet title. Yeah, obviously it goes with that. So we'll take a recess, we'll come back, and we will start with that.
Could I just intercede a couple of things
Yes.
which maybe move this along?
Yes,
First of all, I have Mr. Coleman and Mr. Wiki present today. Obviously, you're not going to allow them to testify as to the anti-lockout and all that sort of thing. So may they be excused.
well, I said Miss Blair couldn't testify. I didn't preclude.
They don't have information as to what amount was paid or not paid.
All right, yeah, they're here often as witnesses. They're both very competent, and they're also both very busy. So yeah, they may be excused.
Yeah,
They're welcome to stay if they wish.
Yeah, I understand Ms. Coleman has a meeting or something that he has to attend to, and I'd like to have him be able to do so.
Any objection?
No, Your Honor, and actually we would ask under MRE 615 that they be excluded because they are going to be potential witnesses in this case. They're not parties, so they need to be sequestered. They can't sit here and listen to the testimony here because I'm assuming that with respect to other claims against other parties or even Ms. Blair that are in circuit court to be removed, they may be witnesses.
All right, well, they'll be excused. These proceedings are being live streamed on YouTube and they're available for review. Mr. Soltis, you may have been able to do that.
I have, Your Honor.
You are specifically prohibited from viewing any of the live stream proceedings on YouTube. It'll be up for maybe 30 days or so. So you're excused. You're also sequestered and you're not to view any of the proceedings that are available on YouTube, and that may be asked later. I don't expect that you will, but I know you're both busy and I thank you for being here and you're both excused.
Thank you, Your Honor. Thank you, Your Honor.
Thanks. Your Honor, then moving on to the other two other counts. For example, count, I think it's, I can't even read my own writing. Count 5 is summary proceedings. We've already ordered that Ms. O'Donnell, Ms. Bowers and Mr. O'Donnell are in the house and denied the summary proceedings brought by Ms. Blair. So I think that's already
I
done.
think so too.
And, you know, I'd be willing to stipulate that they can stay in the house until there is either a order of the court or they fail to go through with the option. But if they don't go through the option, we probably have to be here anyway. So that would take care of that, I think.
All right.
And the quiet title,
Well, quiet title goes with specific performance. If you're going to perform the contract, you've got to provide the title or the deed to the property.
right, but I don't think this court can order the title quieted at this point in Mr. O'Donnell and Ms. Blair, or excuse me, Bowers, because we don't know where it's going to go with regard to the option itself. Will they pay it? Will they not pay it? I don't know. When that happens, we'll be.
I guess, or when the terms of the payment are completed, the defendant would be obligated to provide a deed to the property.
I
So,
think that's within your order of specific performance.
yes. All right. So specifically, we're going to deal with specific performance. We're going to try to figure out how much has been paid.
Thank you.
So as I said, we blocked out the whole day. I went to bed early, got up early. Laura's really looking forward to this. Mrs. Blair, can you hear everything with the system?
Yes,
All
I
right,
can.
very good. I'm glad that's working for you. All
I
right.
never did before.
Well, I'm glad it's new and it's just for cases like this. So I'm glad you can hear everything. All right, let's take a recess. 9:45. We'll resume and jump off a cliff.
Thank you, Your Honor.
Sorry, Your Honor.
Yes.
I did have a question. Since,
Okay, turn the record back on.
Since we're having the third-party defendants be ordered up to circuit court, is my attendance necessary for the
No,
remaining?
you're
of the
welcome to stay if you wish, but for a client to pay for you to sit here. So no, you don't need to remain. And those matters will remove to circuit court. And hopefully part of what we do here may help those cases resolve as well.
Thank you, Your Honor.
All right, thank you. But you're certainly removed for any obligation here today. All right, thanks.
Thank you.
All right, let's take a break. All right, we are back. We've cleared the decks of ancillary issues. We are going to address defendants' specific performance claims, which relate to what purchase price was set and what was tendered by the defendants. Mr. Hatch?
Thank you, Your Honor. Your Honor, I think we do have one more housekeeping issue, and I promise I think this is the last one for the day. There was an order entered for the forensic examination of Miss Blair's phone. Miss Blair has failed to comply with that order. I don't want to file an motion of contempt. I think myself and opposing counsel have come to an agreement as far as a stipulation about when she will produce her phone, consistent with that order, to be examined to extract relevant data off of it. I do want to put that on the record here today so everyone is abundantly clear about when the phone has to be produced and what the location is.
All right,
So
you want to do an order to that effect?
I will, and I would just like to stipulate on the record here today, and correct me if I'm wrong, within 7 days, opposing counsel will let me know when Miss Blair is available. We set it originally at the library in Crown Point, Indiana, to make it convenient on Miss Blair. So we'll set that location and a time, and I just want to make sure there's a cabin date on it. The mirror imaging of the phone will take place within 14 days of today. So I'll work with the opposing counsel and we'll communicate, but it'll happen within 14 days.
Agreed, Your Honor.
All right, very good.
Your Honor, if I may, before we call witnesses, just a brief opening statement.
Yes, thank you.
Your Honor, this hearing is about green lights. So the first question that you probably have is, what do green lights have to do with this case? In life, green lights mean go, carry on, advance, continue. On the road, green lights are set up to give the flow of traffic the right of way. And when scheduled properly, more vehicles catch more green lights in succession. Green lights say proceed. In trial, green lights are affirmations of the truth. They're proof, support, praise, gifts, gas in the fire, attaboys, and appetites. They're cash money. See, we love green lights. They don't interfere with our direction. They're easy like a shoeless summer. Green lights say go and give us what we deserve. Now, green lights are earned, they're not given. And the purposes of today's hearing, we are going to prove by a preponderance of the evidence the relief that Joe O'Donnell and Carla Bowers are entitled to as part of this lawsuit through green lights. Before we get into proofs, I want to briefly discuss the remedies that we're asking the court to award here today, specifically the equitable remedies of specific performance and quiet title. In America, we don't believe in eye for eye justice. We're not here today to lock Miss Blair out of her house and steal her personal property like she did to my clients. But while we don't believe in eye for eye justice, we also don't believe in saying tough luck or turning a blind eye when someone inflicts serious harms on another's life, like what happened here in this case. The American judicial system believes in accountability and consequences. And in civil disputes, our courts impose accountability and consequences through two primary vehicles: money damages and equitable relief. The equitable relief that we are asking the district court to award in this case is what is necessary to restore Joe O'Donnell and Carla Bowers to the position they would have been if Miss Blair had not breached the land contract and had not illegally evicted them from the property. Specifically, at the close of our proofs, we will request that the court enter a judgment in favor of Joe O'Donnell and Carla Bowers against counter-defendant Rosemary Blair, ordering that Miss Blair to perform her obligations under the land contract. Enter an order requiring Rosemary Blair to execute all the documents and instruments necessary to sell and transfer the real property located at 11247 Lakeshore Drive in Three Rivers, Michigan, in fee simple absolute to Joe O'Donnell and Carla Bowers, free and clear of any liens and encumbrances after the parties close on the sale of the property. And enter award requiring the purchase price remaining under the land contract to be set off by the amount of damages that Joe O'Donnell and Carla Bowers are awarded against Rosemary Blair in the circuit court. So the story of this case is best explained through a timeline, which I have as a demonstrative over to my right. Is it okay, Your Honor, if I step away from the microphone and move towards the demonstrative?
Yes. Go ahead.
Your Honor, the evidence in this case will show, we're starting on the left of the timeline, that in June of 2021, Joe O'Donnell and Rosemary Blair entered into a lease agreement with an option to purchase. That lease agreement was temporary, and it was on a single page piece of paper that Ms. Blair drafted until the parties agreed to a further agreement. On June 11th of 2021, Mr. O'Donnell paid Ms. Blair 2 payments, a wire of $24,500 and a cash payment of $15,500.
Just a minute. Let's lock it on that for a minute, Laura, on the left lawyer camera channel.
You got it.
All right.
Okay, good.
Go ahead.
My left side's my bad side, so it's okay.
My front side is my bad.
I got a
side.
face for radio, so on June 11th, there was the evidence will show that a payment was made between Mr. O'Donnell and Ms. Blair, $24,500 wire, and a cash payment of $15,500, totaling $40,000. At or around that time, Mr. O'Donnell, Ms. Bowers, and their 5 children moved into the house. They made subsequent cash payments after that. July 8th, $9,000 cash. There'll be evidence to that effect.
All right, stop, slow down. All right,
July 6th, a $7,000 cash payment from Mr. O'Donnell to Ms. Blair. There'll be evidence to that effect. July 22nd, a $4,000 cash payment from Mr. O'Donnell to Ms. Blair. July 27th, a $10,000 cash payment from Mr. O'Donnell to Ms. Blair. July 27th, a $500 cash payment from Mr. O'Donnell to Ms. Blair. The evidence will show that all of these payments were made towards the purchase price of the lake house. Now we fast forward until November 15th of 2021. That is when Rosemary Blair, Joe O'Donnell, and Carla Bowers executed the more full and formalized lease with an option to purchase, which is commonly understood as a land contract. November 15th, that date, Ms. Blair received a $600 cash payment, on November 12th, a couple of days before they signed the land contract, she received a $600 cash payment from Mr. O'Donnell. There'll be evidence to that effect. On November 15th, she received a $14,400 cash payment from Mr. O'Donnell. That is the infamous picture over here with the $14,400 of cash payments that Ms. Blair received on November 15th at her house in Crown Point, Indiana, from Joe O'Donnell, and Carla Bowers was present as well. That is the same contract that was signed on the same day that Ms. Blair now claims in this case that she did not have capacity to sign. Ms. Blair, there's no comments from anyone during.
Okay,
this
counsel.
So,
Let me do this.
well,
and let me do this. Just a minute. Ms. Blair, I know you got strong feelings about this, and you're listening through the headphones, so you can't hear anything, but hold your comments. You can share them with your lawyer, but don't say anything that be picked up.
I'm
by-
sorry, I can't hear.
Yes, so, but don't say anything.
I won't say
Okay.
anything.
All right, very
I
good.
apologize, Your Honor. I should have asked the court to instruct and admonish the party not to speak during an open statement. So November 15th of 2021, the date that Ms. Blair claims that she didn't have capacity to sign, but she had capacity to receive $14,400 of cash, count the money, and it's sitting conveniently right on top of that land contract. She said she didn't have capacity to sign. So from January 31st of 2022, the next month, up until August of 2022, everything was fine. Joe and Carla in January of 2022 made a $14,500 cash payment to Ms. Blair. The evidence will reflect that. And now the monthly installment payments were made of $2,000 that the court previously heard testimony about. Under the land contract, they weren't required to make any payments. You'll hear testimony here today that Ms. Blair was strapped for cash, in her own words. So they went above and beyond to try to help Ms. Blair out to make installed payments of $2,000 to be offset.
Starting what month?
Starting on February of 2022 and continuing to June of 2022. So $2,000 in February, $2,000 in March, $2,000 in April, $2,000 in May, and actually $2,500 in June of 2022. Two separate payments. One was $500 cash, one was $2,000 cash. I'm sorry, there was another payment made in July. So from February of 2022 to July of 2022, there was $2,000 cash payments, 1 month, $2,500. Everything changed in August of 2022. This is the time that under the land contract, it reads that Ms. Blair, when she wanted to close or consummate the sale of the transaction, she would give Joe and Carla notice. And then within 90 days of that notice, they would close and pay the remaining balance of the land contract. You'll hear evidence today that Ms. Blair sent a text message to Joe O'Donnell on August 4th of 2022, stating that she wanted to close on the transaction. You also hear evidence that Mr. O'Donnell responded and said, let's move forward with the transaction, and was ready, willing, and able to close within 90 days and was working towards securing financing. This is the point in time when everything went wild. At that point in time, Ms. Blair got seller's remorse. She was confronted with the issue that she was actually going to have to part ways with this property.
I'm going to object, Your Honor. This is speculation and it's not relevant to the amount of damages.
Your Honor, it's a demonstrative, it's opening statement, it's not used for the truth of the matter. It's just.
It's, all right, I'll allow it, but yeah, it isn't. I'll allow it.
So circumstantial evidence between August 4th and what happens on August 12th of 2022. Ms. Blair sends the text on August 4th saying, let's close on the sale of the property. She hears back from Mr. O'Donnell. We're moving forward with the sale. She understands that within 90 days, she's going to have to depart with the property. On August 12th, Ms. Blair has her own property condemned. Davies Township comes out. They condemn the property based on what was first a fallen tree in the backyard and what was next some bottle jacks or evidence under the foundation of the house that my client had no idea that were there.
Your Honor, may I have a continuing objection to this form of opening because it's not going to be
Relevant to the amount.
to the amount, and it's also not going to be followed up by evidence. So go ahead.
Some of this I'm aware of because of earlier arguments, and I also handled the condemnation case or the that zoning hearing, not realizing until later that we were dealing with the same thing, and not realizing that there were tenants in the property. But I am aware from evidence that I heard regarding the events of August 12th. I've seen all the photographic evidence, the bottle jacks, the minor damage to the deck. And in fact, so it doesn't go to damages, but it may go to why we are where we are. So I will allow your continuing objection.
Thank you.
Thank you, Your Honor. And it is relevant to our claim for specific performance because under the factors under specific performance, we need to, number one, establish that there was a valid contract. Number two, establish that my clients complied with their obligations under the contract. And number three, establish that Ms. Blair breached the contract. So certainly the condemnation, the self-inflicted condemnation of the property and the eventual termination goes to an element of specific performance. So between August 4th, which was the 90-day text for the closing, and August 12th, the evidence will show that Ms. Blair had her property condemned, which is undisputed at this point as the court has handled that condemnation proceeding. And what happened after the property was condemned? My clients were removed from the property. And at that point, Ms. Blair could circumvent the summary proceeding process. She had them out of the property. So after August 12th, what happens? You'll see a letter from an attorney that Ms. Blair hired from east side of the state of Detroit, Mr. Robert Yonker, that sent them a termination letter saying, relying on the condemnation term of the contract, saying the property has been condemned. And now under the land contract, which Ms. Blair claims that she didn't have capacity to sign, now the land contract is terminated and you must vacate the property. So she had her own property condemned, and then she relied on her self-inflicted condemnation to wrongfully terminate the land contracts in September. Then what happens? In October, after she has her own property condemned, Ms. Blair resorts to self-help and changes the locks on her own property in violation of the anti-lockout statute. I understand that that claim has been removed to the circuit court, but again, that goes to the breach of the land contract. She unlawfully removed my clients from the property and then locked them out, which is a breach of the land contract. In November, Mr. Yonker sends another threatening letter to my clients, now claiming that they've abandoned the property, which is curious because they were trying to get back into the property when they were locked out. And also Ms. Blair had filed for recovery of possession. So my clients never abandoned the property, and that's why we're here today, because they want the properties back. And then December of 2022, Ms. Blair files the summary proceeding lawsuit to regain possession of the property that she already wrongfully evicted the clients from. So that's the story. That's the picture of the case. And then now we get into the damages, or excuse me, the testimony about payments that Ms. Blair received from my clients. Your Honor, as a default has been entered in this.
Take the lock off.
As a default has been entered in this matter against Rosemary Blair with respect to all the claims asserted against her in the counterclaim, we're here today under MCR 2.603 to offer proofs with respect to counter plaintiff's claims for specific performance, which is count 2 in the counterclaim, and quiet title, which is count 6 in the counterclaim. Your Honor, as our first witness, we would call Joe O'Donnell.
Mr. O'Donnell, you may have a little trouble getting there, but if you come around the posters and face me, swear or affirm any testimony you have to give in this matter will be true to the best of your knowledge and belief.
Yes, it is.
Please have a seat. Would you state your name and spell your name for the record?
Joseph O'Donnell, JOSEPHO'Donnell.
Good morning, Mr. O'Donnell.
Good morning.
Or maybe afternoon, midday. Mr. O'Donnell, what is your current address?
28 North Barton Street in Buffalo, Michigan.
And is that the address where you permanently reside?
Yes,
And do you live in the city or the township of New Buffalo?
I live in the city of New Buffalo.
And how long have you lived in the city of New Buffalo?
6 years.
And how old are you here today?
47.
And what properties do you currently own?
I have, 11247 Lakeshore Drive, 22 North Barton Street, New Buffalo, and 28 North Barton Street, New Buffalo.
Now, 22 North Barton Street and 28 North Barton Street, those are in the city of New Buffalo, correct?
Yes, they are.
Okay. And you mentioned 11247 Lakeshore Drive. Do you own that property, or are you seeking to own that property through the proceedings here today?
I'm seeking to own that property through the proceedings today.
And do you have any children?
Yes.
And how many children do you have?
I have 2 biological. I have 5 children altogether. Carla has 3 children.
And what are your children's names? Let's start with your biological children, and then let's go to Miss Bauer's children.
Joey O'Donnell is 12, and then Grant is 5. Those are my biological children. And then Joey Bowers is 12, and McKenna is 11, and Delaney is 10.
And I'll call him Joey B as Joey Bowers.
Joey B is what we call him.
Okay. So Joey B, McKenna, and Delaney are Miss Bauer's biological children, correct?
Yes.
And Joey O and Grant are your biological children.
Yes.
I'm sorry, can you just repeat all their ages again, please?
Yeah, it's
Start with Joey O.
Joey O is 12, Joey B is 13, McKenna is 11, and Delaney is 10. And Grant is 5, sorry.
And where do your children live? That's Joey O and Grant, correct?
Yes, Joey O lives in Ogden Dunes, Indiana with his mom, And Grant lives in LaPorte, Indiana with his mom.
But they still visit you and
I'm
you
with
have,
him half the time. I'm with half the time.
okay. And what about Joey B. McKenna and Delaney? Where do they live?
They live with their mom and me half the week. They're back and forth.
And when you say their mom, who are you referring to?
Carla.
Is that Carla Bowers?
Yes, it is.
And where does Miss Bowers live?
Oh, she lives in New Buffalo, Michigan.
And can you identify Miss Blair or Miss Bowers for the record, please?
Yeah, she's right there.
She wearing a black shirt?
Yes, she is.
Let the record reflect that Mr. O'Donnell has identified Carla Bowers to my right.
No objection, Your Honor.
Mr. O'Donnell, where were you born?
Chicago, Illinois.
And where did you grow up?
Chicago.
And did you attend high school?
Yes.
What high school did you attend?
I graduated from New Buffalo High School.
New Buffalo High School?
Yes.
Is that in the city of New Buffalo?
Yes.
And what year did you graduate from high school?
94, 95.
And did you attend college?
Yes, it did.
Where did you attend college?
Michigan State University.
Go Green. Did you obtain a degree from Michigan State University? What degree did you obtain?
BA in Communications.
Is that a Bachelor of Arts in Communications?
Yes, it is.
And do you recall when you graduated from Michigan State?
Yeah, it was 2000.
And did you obtain any post-baccalaureate education?
Yes.
And what was that education?
I got a law degree.
So you received a Juris Doctor degree?
Yes.
Okay. And where did you attend law school?
Thomas Cooley.
And what campus did you attend Cooley at?
East Lansing.
And what year did you graduate?
2003.
And are you currently employed?
Yes.
Who do you work for?
Myself.
You're self-employed?
Yes.
What type of work do you do?
Pretty much everything real estate. I do construction. I do buying and selling and renting and manage properties. I do pretty much everything real estate.
So do you buy and sell real estate?
Yes.
And do you own a construction company?
Yes.
And do you do residential construction?
Yes.
Do you do any commercial?
No, not necessarily. No.
Were you a realtor in the past?
Yes.
How long were you a realtor for?
About 18 years.
And you mentioned managing rental properties. Do you own and manage various short-term rental properties?
Yes, I have 3 Airbnbs that I own and manage myself. And I have a couple properties I manage for other people.
And the properties that you own and manage yourself, where are those located?
New Buffalo, Michigan.
Is that the city of New Buffalo?
Yes, it is.
Mr. O'Donnell, in your own words, can you please tell the court why we're here today?
Because we were thrown out of our house in August of last year, and we're trying to get back into our house. And I guess we're just trying to get back into our house, and it's the lawsuit was trying to get back into it.
And are you familiar with the property located at 11247 Lakeshore Drive in Three Rivers?
Yes, I am.
And can you describe that property for me?
Yes, it's a beautiful 5-bedroom, 3-bathroom, 3,700 square foot house. It's on the lakefront. It's got a semi-attached garage, and it's beautiful.
How many stories is the house?
3.
Okay. And can you just speak up a little bit?
Oh,
It's kinda
3, sorry.
hard. And paint a picture for me of the house. Start at the front door and then go to the back.
Okay, you walk in and you pull up, it's beautiful. It's at the end of a private road, and there's kind of like a dead end. It's not a cul-de-sac. And then you walk in and the garage is to your right, and you come in and there's a great room. It's 3 stories up, wall glass. It comes down, and then behind that there's a primary in the first floor, which is really nice. And then it's got 4 bedrooms, or it's got 4 bedrooms upstairs. And it's got the beach is incredible. The front yard, it's got a deck dock that go out. It's just incredible. You look out the front windows, it's just a lake, beach, yard, beach, lake.
So let's go to the back of the house. You mentioned that there was a deck, correct?
Yes.
Does that deck look out on a lake?
Yes, it does.
What lake is that?
It's Corey Lake.
Okay, and then take me from, I'm assuming the backyard then connects to the lake. So take me to the backyard to the front of the lake. What does that look like?
You walk out of the house, and then from the glass windows, there's big sliding doors that open all the way up across, and they walk out on the deck, and then you got a nice yard there, and then there's like a little rock wall, and there's a beach, and then the dock's not in now, but the dock goes out, and there's a dock deck that goes way out in front of the house. You just can see it right out front.
And how many feet of lake foot frontage, if you're aware, is on the
50.
house? And describe to me the beach. Is it one of those nasty rocky beaches, or is it?
No,
sandy?
this is actually a special property, because on Corey Lake, some sides you get like a lot of like seaweed and lily pads and stuff like that. And then this is actually like a sand side where it's really nice and smooth, and the bottom's really nice. Kids love it. It's shallow.
Would you say that it's a great family house?
Oh, it's amazing.
And are you familiar with Rosemary Blair?
Yes, I am.
Is Miss Blair in the courtroom today?
Yes, she is.
Can you identify Miss Blair for me and by what she's wearing and where she's
Yeah,
sitting?
she's over there in the black with the earphones on.
We'll stipulate that he pointed to Miss Blair.
May,
And when did you first become acquainted with Miss Blair?
October of 2020.
And how did you become acquainted with Miss Blair?
Her property was on the internet on the Facebook page for Love of Corey Lake.
Now, let me just stop you right there. When you say her property, what property are you referring to?
11247 Lakeshore Drive.
Okay. And sorry, I didn't mean to interrupt you. Keep going. You said it was on the internet.
It was on a Facebook page that was for the Love of Corey Lake, which people post stuff around the lake and everything. And it was a listing for the house for sale by owner.
So the house at 11247 was listed on for sale on for the Love of Corey Lake, correct?
Yeah, Facebook page, yes.
Okay. And is that how you became aware that the property at 11247 Lakeshore Drive was for sale?
Yes.
And again, approximately when did you become aware that the property was for sale?
October of 2020.
And who was selling the property?
Rosemary Blair.
And was it a for sale by owner?
Yes.
Was anyone living in the property when it was listed for sale?
No.
At a certain point, did you approach Ms. Blair about purchasing the property?
Yes.
When was that?
October 2020.
And what did you and Ms. Blair discuss at that time?
Just the terms of, how much we pay and when we could close and this and that.
And did you offer to purchase the property from Ms. Blair?
Yes.
And when was that?
October 2020.
I'm
And-
sorry, I couldn't hear the witness. Could you speak up, sir? if you don't mind?
October 2020.
Loud and proud. I know it's
Right,
not
yeah.
like normal conversation, but you can speak up a little bit. And did Ms. Blair agree to sell you the property?
Yes, she did.
And when was that?
That was in October of 2020.
And was that a verbal agreement or a written agreement?
That was verbal.
And at the time you offered to purchase the property, did you know Carla Bowers?
Yes, I did.
At that time, were you in a relationship with Ms. Bowers?
Yes, we've been living together for about 3 years.
And Ms. Bowers is in the courtroom today, correct?
Yes, she is.
And you've identified her to my
Yes.
right, correct? And did you plan on moving into the property at 11247 Lakeshore Drive with Ms. Bowers?
Yes, I did.
And did you plan on using the property as your primary residence or your secondary residence?
Primary residence.
And why did you want to use it as your primary residence?
Because it has 5 bedrooms and we had 5 kids and it just fit our whole family. It was the first place that we had a chance to get our whole family together and have space.
Was there any financial benefits of having it as your primary residence as opposed to your secondary?
Yes, the taxes would be cheaper as well.
So with
The
that
tax, you get a
homestead, not homestead?
Yeah, deduction for your primary residence, which would reduce the I think by 40% or something like that.
And did you plan on having your biological children live with you at the property?
Yes,
And did you plan on having Ms. Bowers' biological children live with you at the property?
yes,
So is it fair to say that you and Ms. Bowers and your children or her children would live at the property as a nuclear family?
yes.
And why was that important to you?
Because we're in love and, we both, have our kids. And after the pandemic, we were stuck in a little place and we were really looking forward to having the whole family together and just being together and having a big house that's growing and just have a forever house.
And what are some of the things that most attracted you to the property?
Well, it's really unique. You're never going to find anything like this. It's like, it's all glass in the front. So you get all sunlight. It's almost like being in a fishbowl at times. It was Amish built, so it's all cedar. It's just incredible. The outside and the inside, everything is cedar. The doors are even custom made on the interior of cedar. And it's just a really special house. Everything about it. The land that it's set on, it's really close to the lake. It's closer to the lake than any other houses on the thing. And it's beautiful.
What about the location? Was it,
You can't get another location like that because the beach, there's no beaches like that on Corey Lake. There's only a couple spots in that lake that have that kind of thing. So you can't get anything like that.
would you say it's secluded?
Yes,
Okay. Would you say it's peaceful?
yes,
Or were those aspects important to you about why you decided to purchase the property?
yes.
What about the makeup of the house as far as rooms and bathrooms? Was that important to you about living there with your children and Ms. Bowers' children?
Yes, it was.
Yeah, and explain that to me.
Well, when you have there's 7 of us total, and we're all together, so that's a lot of people. And, you know, there's the girls are kind of really close in age, so for them, they don't mind sharing rooms, but it's kind of, we figured that for all of the ages, they kind of need their own room and their own space, and we all kind of need our own space, so to space us out a little bit and everything else, it was just set up perfect. I mean, the rooms, there's like a level for the girls, the boys, I mean, there's bathrooms on different levels, I mean, it's just perfect.
Yeah. And how many bedrooms are in the house?
5.
So that would accommodate
Yeah.
the
everybody.
children. Okay. Would you call the property one of a kind?
Yes,
And would you say that the property is uniquely situated to meet your needs and tastes in a home?
oh, yes, with the garage, with the bathrooms, with the lake, everything.
And I don't mean to be repetitive, but just so the record's clear, can you just specify what those unique needs and tastes are in this home that attracted you to it?
I think we got enough of that.
Okay. And have you encountered any other properties that are similar to 11247 Lakeshore Drive?
No, I don't think you can come by. It's a pretty unique property. I mean, it's one of a kind. You're not going to see anything like that on the lake.
Have you encountered any other properties with similar features of 11247 Lakeshore Drive?
No.
And you're a realtor, correct?
Yeah.
So you look at a lot of listings? Yeah. Have you encountered any other similar properties with a comparable sales price to that of 11247 Lakeshore Drive?
No.
Your Honor, I have binders for you and also the court reporter and opposing counsel as well
That's good.
for our exhibits. Can I approach on?
Yes.
There's a judge's copy. The tab with the numbers on the bottom. And also, there's a mirror copy. Mr. Donald, you have a copy of the exhibits in front of you, correct?
Yes.
Okay. All right, I want to direct your attention to what is marked for purpose identification as Exhibit 1. Can you flip to that for me, please? Have you seen this document before?
Yes, I have.
Can you describe what this document is in your own words?
Yeah, it's a lease agreement to the 11247 Lakeshore Drive.
Your Honor, I'm going to object to this document. The counter complaint speaks of the lease option to purchase, not this document. There's never been anything pled about this document. So it's irrelevant.
All right, I'll note the objection. I'll allow it to come in. Maybe it will help us understand this whole transaction. This is not a lease option to purchase. Well, it is. Anyway, I note your objection. And in defense of you, you just got in the case like 3 days ago. But this is admitted.
Mr. O'Donnell, is this a true and accurate copy of the original?
Yes, it is.
Okay. And you're familiar with Ms. Blair's handwriting, correct?
Yes, I am.
Okay. Whose handwriting is in Exhibit 1?
Rosemary Blair's.
And Your Honor, I think it's been admitted already, but we would offer to admit Exhibit 1.
It is admitted over objection.
Thank you, Your Honor.
Mr. O'Donnell, what's the date at the top of this document?
June of 2021.
All right, I want to direct you to the bottom of the document. Who signed this document?
Rosemary Blair and myself.
And what is the date next to your signature?
July 2nd of 21. Or
And
June,
did you-
or July, sorry.
Would that be July 2nd?
July 2nd, yes.
And did you discuss this document with Ms. Blair before you signed it?
Yes, I did.
What did you discuss?
Just that we needed something to show that we had a lease on the property and that we had everything.
And whose idea was it to draft this document?
Rosemary's.
And what led you to ultimately sign this document?
Just to take possession of the house.
Um,
Have proof that I own the house, or was renting it or leasing it.
And the document mentions that it's a lease and you have the option to purchase the property at 11247 Lakeshore Drive, correct?
Yes.
What was your understanding of the option to purchase in this agreement?
That we paid her the money, and then once she expressed her terms, and we make our balloon payment at the end and take possession of the house.
Objection. This is contrary to the document, Your Honor.
Well, the document speaks for itself.
Right.
We still haven't got a purchase amount yet, but, so had you moved into the house in June or July of 21?
Yes,
When did you move in?
June.
You took away my next question, Your Honor.
Okay.
And why was, well, let me go back, strike that. Did you discuss the concept of a land contract with Ms. Blair at the time you executed this document?
Yes.
And what did you discuss?
We just discussed different ways to purchase the property and how we were gonna get it to her, and she told us she needed money like right away, so we discussed a way of giving her money right away and then give us a little time to close the deal, and then she needed time as well, so.
And what's your understanding of what a land contract is?
We give her a large amount off the beginning of the payment to hold the house, and then during that time, then when you make a balloon payment at the end, you don't make rent payments in between, you just make a big payment, hold the property, and make a payment at the end.
And is your understanding,
Excuse me, counsel, just if I may, counsel keeps referring to this as a land contract.
Yeah, I've been struggling with that throughout the case. Sometimes it's on its face, it says a lease option to purchase, which is not identical to a land contract.
So I'd ask that the council be asked to refer to it as a lease option.
Thank you.
Your Honor, we're just establishing the basis as far as the understanding of the parties about lease option to purchase could be an ambiguous term, so it goes to the extrinsic evidence of the
Well,
understanding of
but
the
we're
parties.
calling it something that it isn't. So let's refer it as the lease with his option to purchase.
Okay. How about just exhibit one?
All right, that's fine.
Exhibit one, why was the idea of a land contract appealing to you?
Because it gave us time to secure financing.
At the time you executed this document, had you given Ms. Blair any money towards the purchase of the home?
Yes,
How much money had you paid her?
I believe it was 24,500.
Objection, Your Honor. I think the council, that Mr. O'Donnell is referring to the demonstrative evidence in order to inform his testimony. I think he should.
Well, first of all, he said, I believe, but, all right. Let's back up. So at some point you gave Ms. Bowers 24,000, excuse me, Ms. Blair, $24,500.
Yes,
And when was that?
that was a wire transfer. Wire transfer on, what was the date on there? It was, sorry,
And I'm gonna get to that. Your
June
Honor.
11th.
You know,
June 11th of 2021.
and we'll get to that eventually.
All
right.
So, yeah.
Okay.
So from your memory, did you pay Ms. Blair $24,500 on June 11th by wire?
Yes, I did.
And what did that payment relate to?
The purchase of 11247 Lakeshore Drive.
And when did you move into the property?
June of 2021.
And was that after you executed this
Yes,
exhibit one, I'll call it? And who else moved into the property with you in June of 2021?
Carla, Bowers, and the kids.
And which, are those all five kids?
Yes,
And did you move your personal belongings in the property with you at that
yes,
time?
we did. Oh,
What did you move in?
well, we moved in tons of stuff. We moved actually all of our stuff from our houses down here, all of the stuff you keep. I brought my safe stuff there. I brought my, all your valuable stuff, the stuff you're gonna keep for our storage boxes, that all our kids' stuff in there, and the blanket, all that kind of stuff. We brought up beds, we brought up dishes.
Not
So-
to interrupt you, but was the house partially furnished when you moved in?
Yes, it was. It was when I first saw it, yes.
Okay. And was that partially furnished by Ms. Blair?
Yes, it was furnishings there that we purchased before the
And was the fact that the property was purchased something that attracted you to the property?
oh, yeah, because it made it made it a lot easier for us to move in, furnishing a 5-bedroom, 3-story house is pretty hard.
And did you live in the property full-time after June of 2021?
Yes,
Mr. O'Donnell, you've reviewed all the pleadings and documents in this case, correct?
yes,
And have you watched other court proceedings in this case on YouTube?
yes.
Do you recall from reviewing that information how much Ms. Blair claims that you have paid her with respect to 11247 Lakeshore Drive?
Yes, 30,000.
That's $30,000?
Yes,
Do you agree with that statement?
not at all.
So if someone were to suggest in this courtroom that you only paid Ms. Blair $30,000 towards the purchase of 11247 Lakeshore Drive, that would be a lie, correct?
Yes, correct.
I want to direct you to what's marked as Exhibit 2. Take a moment to review the document. Let me know when you're finished. Have you seen this document before?
Yes,
Did you help create this document?
yes, I did.
In your own words, what is this document?
It's a summary of all the payments I made to Rosemary Blair for the purchase of 11247 Lakeshore Drive.
And have you gone through all the documents that support this payment summary and verify that those amounts are accurately reflected in the summary?
Yes, I have.
And do you believe that Exhibit 2 fairly and accurately summarizes the payments that you made to Rosemary Blair with respect to 11247 Lakeshore Drive?
Yes,
Your Honor, we would offer Exhibit 2 into evidence as a summary under MRE 1006.
Well, the exhibit summary is ostensibly going to be supported by the exhibits to follow, which are not yet in evidence, but assuming they will connect it, I'll allow it under that basis. Mr. Soltis?
Yes, you made the point, Your Honor, as long as it's supported by the actual documents themselves, not just the summary.
All right, so tentatively, certainly for purposes of testimony, it's admitted.
And Mr. O'Donnell, Exhibit 2, is that on a demonstrative board right next to you? Is that the same document?
yes, it is.
Okay. All right, I want to direct you to what's marked as, for purpose of identification, as Exhibit 3. Have you seen this document before?
Yes, I have.
And are you familiar with this document?
Yes, I am.
What is this document in your own words?
It's a copy of the wire transfer I sent to Rosemary Blair.
And is this document a true and accurate copy of the original?
Yes, it is.
And did you fill out the information that's included in Exhibit 3?
Yes,
Your Honor, we ask that Exhibit 3 be admitted to evidence.
Objection?
No objection, Your
It's
Honor.
admitted.
Mr. O'Donnell, at the top of Exhibit 3, it has a box titled Wire Transfer Sender Information. Do you see that?
yes, I do.
And who does that section identify as the sender?
Me, Joseph O'Donnell.
And the box next down is titled Wire Transfer Information. Do you see that?
Yes,
What is the date identified in that section?
June 11th of 2021.
And that section also identifies the wire amount, correct?
Yes,
And what is that wire amount?
$24,500.
And the next box down is titled Recipient Account Information. Do you see that?
Yes,
And who does that section identify as the recipient?
Rosemary Blair.
And that section also contains a box that says text to recipient, correct?
Yes,
And what is included in that box?
it's that's just the thing that says purchased for 11247 Lakeshore Drive and Three Rivers, Michigan 49093.
And did you input that text into that wire information?
Yes, I put it so they know what that wire was for.
Took my next question. So why did you insert that information?
Just so it would be known what this payment was for.
And was that money actually taken out of your bank account?
Yes, it was.
Green light. Can you do me a favor and put a green sticker next to the demonstrative? Mr. O'Donnell, I want to direct you what's marked for purposes of identification as Exhibit 4. Have you seen this document before?
Yes, I have.
And are you familiar with this document?
Yes, I am.
In your own words, can you describe what this document is?
It's a receipt from money that we paid Rosemary Blair.
And did you take this picture?
Yes, I did.
When did you take this picture?
On June 11th of 2021.
And what device did you take this picture with?
My iPhone.
Is that your personal cell phone?
Yes,
And why did you take this picture?
it's proof of the receipt of payment.
And is this document a true and accurate copy of the original?
Yes, it is.
Your Honor, we would ask that Exhibit 4 be admitted to evidence.
And where did you take this picture? In the house there at 11247 Lakeshore Drive?
This was in, I believe this was in Crown Point.
Okay, so this is Crown Point. Whose handwriting is that?
That's Rosemary Blair's.
Yeah.
All right, maybe admit it.
Your Honor, I don't see it on the,
It's, the exhibit is in the book. He's not referring to the summary at this point.
okay.
I'm not sure what it is we're gonna be talking about, because there's 15,000 June 11th. This is dated June 11th. It says $40,000 toward addendum of $100,000. We're gonna learn more about what that means, but right now Exhibit 4 is admitted.
Thank you.
Mr. O'Donnell, did you watch Ms. Blair write this document?
Yes, I did.
And what is the date at the top right-hand corner of this document?
June 11th of 2021.
And is that the date you remember seeing Ms. Blair write this document?
Yes,
And Exhibit 3 states, received $40,000 from Carla Bowers and Joe O'Donnell towards the addendum of $100,000. Balance of $60,000 to be paid later. What is your understanding of what that means?
that we'd already paid Rosemary 40,000 of the 100,000 that we agreed that we'd pay. And then after we paid the 100,000, then that would be it until we paid the final lump sum. And that this is just a receipt she wrote out after getting the payments for us, just writing it down so we could figure out we were at 40 out of 100.
Okay, and let me refresh your memory. Do you remember testifying about a wire transfer of 24,500?
Yes,
Now, and that was made on June 11th.
yes,
Did you make an additional payment to Ms. Blair on June 11th?
yes.
What was that payment amount?
That was for 14,500.
That'd be 14,500 or 50?
15,500. I'm sorry.
Objection, Your Honor, reading suggested. There's no document to support that either.
But there's
Unless I haven't.
Hold on, Joe.
All right. It was leading, but I'll allow the answer.
it was 15,500.
Okay, so let's look at the $40,000 referenced in that document. You see that?
Yes,
So you paid Ms. Blair 24,500 on June 11th, correct?
yes.
Okay. Now, is there some type of a math that would take to get to $40,000?
Yeah, the 15,500 plus that amount came out to the 40. And that's why she wrote this, was to put the, show us that that's what it was, the 40, made the total 40 on that day, because she got separate payments,
All right, how was the 15,500 paid?
cash.
Now, this is a question I've been dying to answer since I've seen these pictures of bundles of $100 bills. Why did you do these transactions in cash?
It was at Rosemary's direction. She said that her kids were trying to, had access to her bank account, that they were trying to take her money. And she said that she only needed cash. That's the only thing that she could work with. I think I have that on a text somewhere. 'Cause I mean, after the wire, she said she couldn't do it. It took like 4 days for the wire to go.
So you had to go to your bank and get large amounts of cash
Yeah, I certainly did.
in $100 bills
Yes, I did.
because that's the way she wanted it?
Yep, that's the only way we could do it.
Did you pay Ms. Blair $15,500 on June 11th of 2021 in addition to the wire we went over?
Yes, I did.
And how did you pay that?
Cash.
And what was that payment related to?
The purchase of 11247 Lakeshore Drive.
And Exhibit 4 actually references the house at 11247 Lakeshore Drive, Three Rivers, Michigan, correct?
Yes.
Okay. So as of June 11th of 2021, how much money had you paid Ms. Blair relating to the property?
$40,000.
And is that consistent with what Exhibit 4 states?
Yes.
Green light. Can you put a green sticker next to Exhibit 4? All right, Mr. Bell, I want to direct you to what is marked for purpose identification as Exhibit 5. Have you seen this document before?
Yes, I have.
And are you familiar with this document?
Yes.
In your own words, what is this document?
It's a receipt for money that we paid Rosemary.
And did you take this picture?
Yes, I did.
When did you take this picture?
On the July 8th, 21,
And what device did you take this picture with?
my iPhone.
And is this document true and accurate copy of the original?
Yes,
And do you recognize the handwriting in Exhibit 5?
yes.
Whose handwriting is that?
Rosemary Blair's.
And did you watch Ms. Blair draft this document?
Yes, I did.
Your Honor, we would ask that Exhibit 5 be admitted into evidence.
Your Honor, I don't think any foundation has been laid as to what this for. I mean, if the council could do that, I'd appreciate it.
Say that again.
There's no foundation as to what these figures represent.
Well, I guess we're gonna learn. He testified that this is a receipt that Miss Blair made out in his presence and he photographed it. And so for that, it's admitted. As to what it means, I guess let's hear a testimony now.
Yeah, I was just going through the authentication phase, Your Honor, and then obviously now we'll go into the testimony about the understanding of this, but I think we've laid a proper foundation for the authentication. Where were you and Ms. Blair located when this document was drafted, Mr. O'Donnell?
We were located at Rosemary's house.
And is that in Crown Point, Indiana?
Yes,
All right, I want to direct you to the date that is written down as July 6th of 2021. What is written next to that date?
7,000.
And what was your understanding of what that means?
I paid her $7,000 cash that day.
And did you actually indeed pay Ms. Blair $7,000 on July 6th of 2021?
Yes, I did.
And what form was that payment in?
Cash.
And how did you deliver that money to Ms. Blair?
And
And what was that payment related to?
the purchase of 11247 Lakeshore Drive.
Can you put a green sticker next to Exhibit 5, please? Green light. No, it's just the 6, please. All right, I want to direct you to the date that is written down as July 8th of 2021. Do you see that?
Yes, I did.
What's written next to that date?
9,000.
And what's your understanding of what that means?
We paid her $9,000 in that day.
And did you indeed pay Ms. Blair $9,000 on July 8th of 2021?
Yes, we did.
And what form was that payment in?
Cash.
And how did you deliver that money to Ms. Blair?
And
And what was that payment related to?
the purchase of 11247 Lakeshore Drive.
And where were you actually located when you gave that payment to Ms. Blair?
At Rosemary's house.
Is that Crown Point, Indiana?
Yes.
Green light. Can you put a sticker next to that exhibit, please? All right, a little math equation. As of July 8th of 2021, how much money had you paid Ms. Blair?
We had paid Miss Blair $56,000.
So that amount already exceeds the $30,000 that Ms. Blair claims that she was owed in this case, correct?
Yes. I mean, she writes it down right there from the 100,000. She has it right down.
And was all of that money related to the purchase of 11247 Lakeshore Drive?
Yes, it was.
All right, I want to direct you to the bottom of Exhibit 4. Do you see where there's a reference to 56?
Yes.
And does that number align
This
with,
is exhibit 5.
Or is it-
excuse me, Exhibit 5? Does the reference to 56 align with the 56,000 of cash that you paid Ms. Blair as of July 8th of 2021?
Yes, it does.
All right, I want to direct you to what's marked as Exhibit 6. Have you seen this document before?
Yes, I have.
And are you familiar with this document?
Yes.
And what is this document?
It's a receipt for money we'd given Rosemary Blair.
And did you take this picture?
Yes, I did.
When did you take this picture?
July 22nd of 2021.
What device did you take this picture with?
My iPhone.
And are you familiar with Ms. Blair's handwriting?
Yes, I am.
Whose handwriting is that in Exhibit 6?
It's Rosemary Blair's.
Did you watch Ms. Blair draft this document?
Yes, I did.
And where were you located when Ms. Blair drafted this document?
Her house.
Would that be in Crown Point, Indiana?
Yes.
And does this document appear to be a true and accurate copy of the original?
Yes.
Your Honor, we would move for the admission of Exhibit 6.
Under the same concerns from Mr. Soltis, exhibit 6 is admitted.
And what is the date at the top of Exhibit 6?
July 22nd of 2021.
And is that the same date that you recall seeing Ms. Blair draft this document?
Yes.
And exhibit states received from Carla Bowers and Joe O'Donnell $4,000. Correct?
Yes.
Did you pay Ms. Blair $4,000 on July 22nd of 2021?
Yes, I did.
What form was that payment in?
Cash,
And how did you deliver that payment to Ms. Blair?
hand,
And what did that payment relate to?
the purchase of 11247 Lakeshore Drive,
And whose signature is at the bottom of this document?
Rosemary Blair's.
Now, during the time of all these payments, is there any other reason that you would have been paying money to Ms. Blair other than the purchase of the property?
No,
You didn't have any other business transactions or dealing with
No.
Ms. Blair? Green light, can you put a green sticker next to Exhibit 6, please? I want to direct you to Exhibit 7, please. And Exhibit 7 consists of 2 pages, correct?
yes.
And are you familiar with both of those documents in Exhibit 7?
Yes.
All right. What is the first document in Exhibit 7? Explain to me what that is in your own words.
This is a picture that I took of, I made payment to Rosemary in her car, and she was drawing up the receipts. So I took pictures. I took pictures of all these.
When did you take this picture?
On July 27th of 2021.
And where did you take this picture?
We met at a gas station between our houses somewhere, and it was in Rosemary's car, but we met halfway between our houses. I just paid her on the gas station side of the road.
And again, why did you take this picture?
Just as proof that I made the payment.
And what device did you take this picture with?
My iPhone.
And if you flip over to the second page of Exhibit 7, can you describe what that document is?
Yeah, it's a receipt from the payment.
And whose handwriting is the second document, Exhibit 7, made up of?
Rosemary Blair's handwriting.
And did you watch Ms. Blair draft this document?
Yes, I did.
And is the second page of Exhibit 7 the same document that Ms. Blair is drafting on the first page of Exhibit 7?
Yes, it is.
And are the documents in Exhibit 7 true and accurate copies of the originals?
Yes, they are.
Your Honor, we would ask that Exhibit 7 be admitted to evidence.
On both pages, same issue, same concern is admitted.
All right, if you turn back to the first page of Exhibit 7, which is the picture of Ms. Blair. Are you there?
Yes.
Whose car is that picture taken in?
That's Miss Blair's car. That's Rosemary's car.
And what's Ms. Blair doing in that picture?
She's writing the receipt for the money paid.
All right. And what's located next to the armrest in that picture?
Pile of cash.
And do you recall how much cash that was in that picture?
Yeah, it was $10,000.
And did you give all of that cash to Ms. Blair?
Yes, I did.
And what did that payment relate to?
The purchase of 11247 Lakeshore Drive.
And if you turn to the second page of Exhibit 7, what is the date at the top of that document?
July 27th of 2021.
And is that the date when you remember seeing Ms. Blair draft this document?
Yes, it was.
And Exhibit 7 states Joe O'Donnell and Carla Bowers, $10,000, correct?
Yes.
What's your understanding of what that means?
It was meant that we paid her $10,000 towards that 100,000 we were talking about, and we had a balance left of $30,000.
And did you actually pay Ms. Blair $10,000 on July 27th of 2021?
Yes, I did. It
And what form was that payment in?
was in cash.
And again, how did you deliver that payment to Ms. Blair?
I hand delivered it.
And again, what was that payment related to?
Just the purchase of 11247 Lakeshore Drive.
Whose signature is on the bottom of Exhibit 7?
Rosemary Blair's.
Green light, can you put a sticker next to Exhibit 7, please?
Sure can.
All right, I want to direct you what's marked for purpose identification as Exhibit 8. Have you seen this document before?
Yes, I have.
Okay. And are you familiar with this document?
Yes, I am.
Did you take this picture?
I certainly did.
When did you take this picture?
On July 27th of 2021.
What device did you take this picture with?
My iPhone.
And are you familiar with the handwriting Exhibit 8?
Yes, I am.
And are you familiar with Ms. Blair's handwriting?
Yes, I am.
Whose handwriting is in Exhibit 8?
Miss Blair's, Rosemary's.
And did you watch Ms. Blair draft this document?
Yes, I did.
Your Honor, we'd ask that Exhibit 8 be admitted into evidence.
Yes, it may.